Hi everybody, welcome. My name is David Wolff. I'm an attorney at Cantor, Wolff, Nicastro Hall. Today I'm going to be talking to you about slip and fall cases in New York and some successful ways to win them, some information in case you're looking for a slip and fall attorney that's really important to know, and just kind of go through and talk to you about slip and fall cases and what you need to look for to see when you have a slip and fall case and when you don't. So first, most basic, simple question that I want to start with today is, what is a slip and fall case? So a slip and fall case, or a premises case it's sometimes called, really simple. Anytime a business or property owner has any sort of dangerous or defective condition that's present, and that dangerous or defective condition causes or partly causes the person to fall. So really, can seem a little bit tricky, but it's really not that tricky in the sense of what we need to prove and what we need to decide. So that is, first of all, a dangerous or defective condition. So that's where an attorney can really help you with that situation. I've had so many interesting cases, and let me go through a couple examples right now for you and some of the common ones that I see every single day. So number one, the most common one in the Buffalo and Western New York area and also throughout the state that I see, and let's say in Long Island and New York City and Albany, all these types of cases, I've handled them all over. Ice cases, okay? Ice cases, that is a dangerous or defective condition. Somebody is walking, they don't see the ice, and that ice causes the person to slip or fall. Now, one of the most common, I'll get to this at a later time, but one of the most common things you'll hear is, oh, it was black ice that caused me to fall. That is a little tricky because it needs to be a dangerous or defective condition that is readily observable, that should have been observed or should have been looked for in the case if they didn't provide an inspection, the property owner, something like that. But an inspection needs to have been able to find that defect. So one of the things that I always find is here's an interesting case that sometimes requires an attorney because it can get really tricky, even though it sounds simple. So let's say somebody goes to a restaurant and they go to pick up a coffee mug. And when they pick up the coffee mug, it breaks apart immediately. And just right when they pick up the handle breaks off. Nothing that they did wrong, anything like that. It's clearly owned by the property owner. But in that situation, they pick it up and it breaks. Well, that's a situation where a premises case where, yes, it was defective in a dangerous condition, but should it have been able to be readily observed? Well, that's where you need an attorney to kind of argue, yeah, it's an old mug. If you would have properly inspected, looked at the mug, something like that. But let me get back to the slip and fall cases, of course. That's why you're here to learn about those. So ice cases, the other ones we always hear are supermarket falls with water. Here's where we have tricky parts of the case, okay? Let's say some customer is walking down the aisle and a customer knocks off a can of Sprite or Sierra Mist, Starry these days, they switch it up so much. And as that customer knocks it off, he knocks it off the shelf and causes the pop to go everywhere. It's a clear color. And then you know what? The person's like, oh, I'm not touching that, I'm walking away. And then about 2 minutes later, the next customer comes down that aisle and they don't see the empty can of Sprite and they are walking and they're just normally looking like shopping at the aisles, and boom, they slip and fall in that situation. And that, let's say that Sprite that's on the ground, that's a dangerous and defective condition, right? It can cause people to fall. But the reality is that dangerous or defective condition, it likely wasn't readily observable or wasn't inspected. The property owner didn't have notice of it, okay? That's probably the better way to put it. So you have to have notice. They have to have known or should have known about the dangerous condition. So what does that mean? Well, if an employee walks by and sees there's a bunch of Sprite laying on the ground and they go, oh, I'm going to go clean that up, and then just walks away and leaves that sitting there, and then the customer comes down the aisle and then the customer falls, well, there we have an argument. We have an argument that what they did was negligent. You'll hear that term. Was what that worker did unreasonable? Not putting a cone up or saying, hey, I need somebody to come over here and watch this. So really, that's a trap-like condition, dangerous and defective. They had notice, they had actual notice, right? And they didn't do anything about it. Or they were going to do it and it wasn't a reasonable thing what they did. So that's one thing. They can have actual notice. So Let's say you have a leaky gutter at a property and that gutter causes water to come down and causes ice to form. That's a recurrent condition. That's something that happens all the time. That's a leaky condition that they have actual notice that the gutter always leaks and yet they leave it like that. Not good, not good, not good for property owners to do that. But let's say the other option you have to prove or have the ability to prove, so it's either you have to have actual notice of the dangerous condition or you have to have constructive notice. What does constructive notice mean? Well, constructive notice just means, very simply, should they have known about the damaged or dangerous condition, I should say, through a reasonable inspection. So let's say some property owner owns a home, okay, and they don't go to the home ever. They say to somebody, hey, you could go use the home next week. And that person goes and gets on the property and it hasn't been touched in a while and they get in and they slip and fall on ice on a gutter. And the last time that owner had checked out the gutter was a year before. And that gutter hadn't been looked at in a long, long time, and it was causing this leaky water where there was ice buildup. You know, we get an investigator and the neighbor says to the investigator, you know, I've seen that leaking every single day for the last year, 2 years plus, and nobody ever did anything about it. And I always said, if anybody walks over there, somebody's going to fall on that ice. Boom, that is constructive notice. That's what we're looking for. So we've got dangerous or defective condition, we got to have notice, and then the third prong is we've got to have that dangerous or defective condition with notice of it cause an injury. Causing an injury. Well, that means a few different things. A lot of people on the defense side right away, they're going to blame you. They're going to say, hey, this was your fault that you fell. You should have seen that ice, right? Or, hey, you should have seen the water that was on that supermarket floor. Well, that's an argument that they have, but all we have in New York State, is a comparative fault state, meaning you can have 1% of fault on the other person, or the business, or the owner of the property, and as long as we have that 1%, then they are liable for that 1% or whatever percentage of damages of the pain and suffering that they caused. So let me give you an example. Somebody's walking down the street, they see really, really severe ice on a sidewalk. And they can turn around and walk across the street and walk down the other sidewalk in that situation that is cleared across the street. Or they can choose to walk over that dangerous condition. And if they walk over that dangerous condition, they're really putting themselves in a situation where they could fall. And guess what? The person did fall, and she suffered a really bad neck injury, ended up needing a neck surgery. So very, very, very severe injuries. We've got a situation where a person made the decision consciously to walk over that. Does that mean that person doesn't have any ability to recover in that situation? No. Let's say if the jury came back and decided it was 50-50, then you would take the total damages amount that was awarded for the neck surgery, let's say it's $1 million, just for numbers' sake, and you would divide that in half, okay? So the actual award of what the business owner, through their insurance almost entirely, would be $500,000. So we've got to have all three of those prongs, or four of those prongs if you want to divide it into four. So we got to have dangerous or defective condition. We've got to have notice of that dangerous defective condition. We've got to have that it was a cause of an injury. The dangerous defective condition, the ice caused the person to fall, caused the person to get injured. And that injury is the fourth prong. If you don't have an injury, I always hear this one, I could have died. It was painful for an hour and I got really bruised up, but I'm okay. I'm 100% okay. But I could have really gotten hurt. Coulda, woulda, shouldas in New York state law, they don't count. In those situations, you really can't get a recovery for that. But there are situations where people get hurt and they need more treatment. And in that situation, we can assist in making sure that they're getting the treatment that they need. So we can support the idea that they are injured. Because the only person that truly knows they're injured is the person that fell. Until they go get help, they've got to go get help in that situation. So the first thing, the broad answer, that is what a slip and fall is. So let's break it down. This is kind of our section 2 that we'll talk about. So section 2 is it always your fault if you fall at a business? The answer is absolutely not, okay? You as a consumer have rights. You as a customer, as a member of the public, have rights under the law in New York State. This is such a thing where there's victim blaming in our state at times, and it really is, the law could not be more clear. What needs to be shown is that there is a dangerous or defective condition. So we've talked about some of the premises liability slip and fall cases already involving ice, involving water. Now let's talk about a different type of dangerous and defective condition. Let's talk about a broken sidewalk, okay, a defective or broken sidewalk. Some people think that, well, in that situation, somebody's walking down the sidewalk and they walk and they're not looking where they're going. I've had this happen before quite a bit. It's a common one I hear. Walking their dog around the neighborhood. And let's say that person knows, hey, I walk by this one property every single day. And on the sidewalk every single day, that one property, there's always this one raised piece of concrete that's about 2 inches, okay? So we're talking about a piece of concrete that's a tripping hazard, okay? It's dangerous, but it's probably a pain in the butt for the owner to change. And in each township, this is where it gets a little bit tricky. So let me give you an example. In New York City, okay, I've got a case right now in Times Square. All right, somebody's walking down Times Square. They hit a piece of concrete that's raised about 1.5 inches, 2 inches, suffer catastrophic injuries, very, very severe injuries. And in that situation, New York City has an ordinance. They have a law, okay, that says, hey, we are not, the city, we are not going to be responsible for fixing everybody's sidewalks. You know who is going to be responsible? Even though it's our property, we own the sidewalk, okay? If you buy the piece of property in front of abutting that sidewalk, you're going to be responsible for the personal injuries that you cause if you don't repair your sidewalk. So take care of your sidewalks. If you don't, you're going to be held liable for that situation. Same in Buffalo. There's ordinances in Rochester, in Albany, a lot of the bigger cities. There's ordinances in a lot of those that protect the member of the public. The idea is let's give them a right to have a safe sidewalk, a sidewalk in good repair when they walk. And even though they might know that that sidewalk, let's say they walk by it every day, let's get back to that dog example, and they walk their dog there every day. Let's say one day they just forget. Okay, and they trip and they fall. Well, in that situation, are you at fault for that situation because you forgot? The answer is maybe, but probably not. And you need to get a lawyer to argue that. And the reason I say you really need a lawyer is because of what ultimately you're trying to do in a case like that. Let me explain. Let me further explain. When you fall in that situation, I get that call, right? I get a call that says, hey, Dave, I was walking down the street and I was walking my dog and I forgot about this raised sidewalk and I fell and I broke my wrist. Serious injury, they're going to be out for a couple months. Let's say they're missing time from work. And they say, what can I do? I knew it was there, Dave. I'll tell you, I knew it was there. Well, in that situation, what my argument is always to the defense, and it's a very effective argument, is that, look, this person made a split-second misjudgment of error. You know, they didn't think or they forgot that that was there. All right? That happens as a split second. Whereas your client, okay, made a premeditated decision every single day. When they walk by that, they know every single day that that is dangerous and can cause somebody to fall, and yet they do nothing. So we've got months or even years sometimes of just general willful disregard and just completely ignoring dangerous conditions versus one split-second decision of somebody forgetting that there was a raised piece of concrete there that could cause them to fall. It's a really effective argument. Sometimes it really works. Sometimes the defense attorneys want to continue to fight you. I love the argument in front of a jury. I think it's really, really effective. I think it's a great argument in front of arbitrators. Just speaking from a very plain standpoint, is it always your fault if you slip and fall out of business? The answer is no. Businesses have a duty to keep things safe. Homeowners have a duty to keep things safe. It's as clear as day under New York law. So let's talk about something that prevents a lot of people from bringing a lawsuit. And that is, if there's a warning sign, does that mean I can't bring a lawsuit for a slip and fall case in New York? The answer is, if there's a warning sign, that does not prevent you from being able to bring a case in New York State. What do we do? What do we see always at amusement parks when we go there, right? Or movie theater tickets, or a lot of different concert venues, right? Look on the back of the ticket, and the ticket says, hey, you assume the risks of going to this and you can't bring a lawsuit, and they'll put on all this language, and really a lot of times that language isn't worth the paper it's written on. That language is designed to do one thing, to trick you into not bringing a lawsuit when under New York State. Any sort of warning signs or signing away your right to sue, those are unenforceable in New York State. So that just means very simply, like, if somebody has a warning sign up, the only thing that it can do is go to the culpable conduct of the other person. So let me give you an example. Let's say the Sprite has fallen on the floor, it's spilled everywhere, and let's say a worker walks up, they start mopping. Okay, and they clean up that Sprite, but it's still very slippery, it's still wet there, right? It's drying. And let's say they just walk away and they don't put a warning wet floor sign out, okay? In that situation, there's no wet floor sign, there's no warning sign. That would be where we'd argue that they were negligent. You have to make sure that, that's an unreasonable thing to do. But let's say they put the wet floor caution sign out, but they put it hidden in an area where somebody couldn't see. Again, unreasonable, not okay, all right? But let's talk about a situation where somebody's walking down the street, and let's say they reach a point of a sidewalk, and that sidewalk is all icy, and across the street, it's icy too. And there's really no other way to traverse across. But the owner has posted a sign out front on the lawn. He thinks he's being really smart. He thinks he's being really clever. He says, listen, walk at your own risk. These sidewalk might be slippery or icy, but I assume no responsibility for any sort of falls, and you're responsible for doing that, for getting across safely. It's your responsibility, not mine. Guess what? That is unenforceable in New York State. You can't sign away your right to take care of your property. You still have to take care of your property. Now, if somebody looks at that and decides, hey, I see the warning sign that says it's really icy, but I'm going to walk anyways, could a jury determine, yeah, well, you have some responsibility in that? Absolutely. But at the end of the day, it's still the owner's responsibility there. So the question, are you unable to sue if there's a warning sign posted? The answer is you are able to sue even if there is a warning sign that says that something is dangerous or defective. It just goes to whether or not you had some culpable conduct, and it's really an argument that is made in the courtroom or behind the closed doors when we're really arguing the value of the case. Okay, so let's talk about an attorney for a second and why an attorney is important. And the reason why an attorney is important, and the question that I always get is, what needs to be done to win a slip and fall case early on? So let's talk about early on in the case. If you can, let's say you slip and fall in a situation like this. Let's say you're walking down the street and you fall on ice. Pictures. Pictures are so important. They tell a really good job of verifying the person's injuries. If you don't have pictures, that's okay. That doesn't mean you don't have a case. It just means that the attorney might need to think a little bit more outside the box in that situation, or we need to use your testimony to explain why those pictures aren't necessarily needed. Sometimes they are, sometimes they aren't, but most of the time we can get away without pictures. But always, 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 if you're in a fall, first thing you should do is get medical attention. Second thing you should do, if you can, get pictures. Those are really, really important things that you can do right away to help your potential case. And then the third thing I say is call an attorney. And the reason that I'd say to call an attorney is because a lot of people want to try to handle the case, maybe themselves or something like that. But the only way these cases work is ultimately you are threatening the insurance company that we are going to take the case the whole way and win at trial. And if you don't have an attorney that is a trial attorney, somebody with experience in winning these types of slip and fall cases, then the insurance company is going to look at your claim and they're going to say, hey, yeah, they're hurt and yeah, maybe we're at fault, but are we really going to lose at trial? Nah, we're not going to lose. Let's take our chances. We know that person that doesn't have an attorney, they're probably thinking to themselves, what do we care? Or they're thinking to themselves, oh, that firm, that's a settlement firm. We don't have to worry about them at trial. And that's really, really important, is you find a trial-ready firm for a slip and fall case. Somebody with experience that has done these cases before. What should I look for in an attorney? okay, for a slip and fall case in New York. Number one, somebody who has trial experience. It's so important, okay? Trial experience is where you're really threatening the insurance company that if you don't give us a good settlement offer, we are going to take you to court and we are going to win. Okay? Your attorney will be able to talk to you about the risks and things like that of going to trial, because ultimately trial is risky and trial can be a very, very difficult thing to win if you don't have somebody with good experience or a good track record in that situation. So number one, why you should get an attorney is because verdicts drive values of cases. When we're talking about, yes, you could be hurt, yes, the other person could be responsible. The reason that I have a job is because insurance companies don't do the right thing, okay? Insurance companies are out for themselves. They're out there to do one thing. They're out there to make sure they protect their insured, and they're there to make a profit. So keep that in mind. They are not there to help you. They are not there to pay out. So when we talk about why it's important to get an attorney or what you're looking for in an attorney, get somebody that is trial ready, that somebody has experience. Number two, find somebody that you feel comfortable talking to. You know, I can't tell you how important it is for me to communicate with my clients. I give pretty much every client my cell phone number. I get texts throughout the day, throughout the night, throughout the weekend. It's no problem. I'm happy to talk with people and make sure that they understand the process. So get an attorney that communicates well. What do they need to communicate to you about? Well, they need to give you a good plan for how you can do what is needed to win the slip and fall case. And they also need to communicate what they're doing so you understand the process, so you're not confused, surprised by every step that we take. Okay? So what does that mean exactly? Well, that means explaining what the steps are to a lawsuit. Okay? Explaining why we're doing a deposition of this person, let's say a business owner. It might mean why we're not going to see this particular doctor, or why you need to see this particular doctor right away. All of those things, communication is really important. So trial ready, so they got that scary face of, hey, we can take you to trial. And then the nice face with you is communicating the risks. So good communication is number two. The third thing that I'd say is really important to look for in a slip and fall attorney is someone who has experience in particular with slip and falls in the area that you're in, okay? So I handle cases throughout the state. I handle cases in Albany, I handle cases in New York City, I handle cases in Buffalo. I am appalled sometimes when some of these out-of-state lawyers try and come in and try and act like they know New York State law and then forget or don't know about key important information that is needed. So get somebody that is well known across the state or well known in the area that you're looking for the case, because those people, okay, those attorneys know the ins and outs of the particular type of slip and fall case in New York State. And every state is different as far as what needs to be shown and what needs to be proven. So those are the three things that I would say are really, really important when you pick out an attorney. The next topic that I want to kind of talk to you about is, I always get asked, do we have to sue the case? Do we have to sue the case in New York to get a recovery? Do we have to go to court? All right, that's kind of another one. Do we have to go to court when I have a slip and fall case in New York State? The answer is no, not always. Every case is different. Sometimes we're able to resolve cases outside of court. In fact, maybe a third to 50% of those cases we can settle before we have to go to court. And the reason that we're able to do that, the reason that we're able to settle those, is because they know at the end of the day that we have the ability to bring the case the whole way and win at trial. So why not pay now, save the costs of going to trial, and then more money goes into your pocket, less time on those cases. And sometimes insurance companies will give a good settlement offer pre-suit. Sometimes they don't. But it's always up to you, the person that's injured, as to who or as to what is done. Me personally, I'm not somebody who just makes decisions willy-nilly and just doesn't think about what's best for the client. I had this case once where she was petrified of going to court. And she was like, David, I would rather pass on $100,000 than have to go into court and sit in court and know in any way that I'd have to go in front of people and speak. So I told her, you have two options. Number one option is let me help you. Let me sit you down, get you comfortable with the process. Let me get you prepared, okay, for everything that they're going to ask you so you feel 100% prepared. And see if you still at that point feel like, hey, I want to take a lowball settlement offer if they're not willing to go higher. So that's number one, is let me help you, okay? Or number two is let me try and get the highest possible offer I can right now without you having to go to court, and you can make the decision yourself. I'll talk you through the timeline of how long I think this case is going to take, where I think I can get the insurance company at pre-suit, middle of lawsuit, and right before trial. I can talk about all those things. And you make the decision. That's the thing that's always very frustrating, is people don't realize that they are in control. Okay, they're in control in that situation, and they don't realize that they ultimately have the ability to make that decision for what is best for themselves. I don't want to be the one to determine that. You are a smart person. You know exactly what you need and what you don't. You know if you want to get things done right away. So I think really from my standpoint, that's super important, is to remember you're in control and that ultimately you don't have to always go to court. And just like the other way, we can push it to court. We can rush things to go to court right away. Sometimes it's not always the best thing to do, but I'll talk to you and advise you as far as what your options are at that point. Let's say you've got an attorney and that attorney talks to you and says, hey, I want to sue your case. A lot of times people want to know, what are the steps of the lawsuit, the actual lawsuit, okay? So let's talk about pre-suit and post-suit, okay? Let's say a pretty typical standard fall on ice case or a fall on a concrete case. Pre-suit, you'll meet with the attorney, give them all the information that they need, and then treat. Medically treat, okay? So let's say you suffered a broken leg. In that situation, you have a fractured leg. Let's say you have to get a cast on it or you have to have surgery. In that situation, when you have a cast on it or have surgery, we don't want to settle your case until we have a great understanding of how hurt you really are. So say you have the surgery or whatever the step is in as far as the broken leg for medical treatment. Well, I'm not going to, like a month into your case, unless there's like a low insurance policy. There's exceptions, of course, but I'm not going to be calling the other side if they've got $1 million insurance policy and being like, hey, let's settle the case right now, because that just invites a lowball offer, or an offer that doesn't recognize, really I would say it doesn't recognize that there's risks that you have with treatment. This is why cases sometimes can take a long time. A broken leg case, like, we don't know how your leg's going to be in 3 months, 6 months. And we want to make sure that your leg is fully healed, where it is as good as it's going to get, or it's back to 100%. Once it reaches that point where a doctor's like, hey, Dave, you know what? This particular broken leg, yeah, she's got a limp. She's going to have this limp for the rest of her life. That usually takes like 9 months to a year to determine that. Or number two is, let's say it heals completely after 2-3 months. Well, then in that situation, yeah, that's a situation now where we can have a conversation potentially with the insurance company about trying to get a value on your case pre-suit. So really I would say the majority of initial time is going to be dedicated to making sure that you are getting the medical treatment that you need to get better. So number one, medical treatment that you need to get better. Really important. And the attorney is going to be taking steps behind the scenes, preserving evidence, gathering more evidence, gathering medical records, determining the best course of pushing the insurance company, getting out letters early on the case, and warning the insurance company that we are going to hold you accountable for this situation. Here's what happened. This person's really hurt. They're going to continue to be hurt, and you guys are in big trouble here. That's what I like to call them sometimes, big trouble letters. So get those big trouble letters out. Then at that point, let's say sometimes we sue cases right away, sometimes we wait because it's in the best interest of the client to wait at times. But once we've decided to sue the case, okay, how long does that take? Well, sometimes it takes years, okay, and that's because, let's say there's a lot of steps, and I'll go through all those steps for a court case. And sometimes it takes years, like I said, because we're still determining how hurt you are, especially back and neck cases. This is very common. Like back and neck cases, they take longer because the back and neck takes a long time to heal. Sometimes it heals quickly, sometimes it takes longer. The last thing I want to do is settle your case when 2 years from now you might be having a major procedure, something like that, that is going to affect the value of the case. So let's say we've sued the case. The suit starts with what's called a summons and complaint. A summons complaint is just a document that says, hey, you guys did something wrong in a slip and fall case. You guys have a dangerous or defective condition. You caused my client to get hurt, and you caused her an injury, okay? So we get that sent over, a process server sends that over, and it's filed with the county, and then it's served on the defendant. And then the defendant responds with something called an answer. And guess what? 99% of the time, the defense responds with an answer that denies everything. Hey, we're not at fault, you're responsible for this, and you're not even hurt anyways. Love those answers. They come in 98% of the time. It's just what happens, and then we get to say, hey, you're wrong, here's why. So how do we show them that they're wrong? Well, the next step after they've answered is something called paper discovery. Paper discovery is where the defense gets to start. They ask a bunch of details, such as what are the injuries the person's claiming? What are the theories of why that we are at fault? What are the theories of why you're not at fault, why my client isn't at fault? They'll ask for medical bills. They'll ask for all lost wages. They'll ask for anything like paper-wise, anything to be able to question them in the future, because really discovery is about previewing trial. Think of discovery as previewing trial. So then don't think that they get to ask all this stuff to us. Guess what? We get to ask things for them. So we get to ask for incident reports. That's something that I always am really, really interested to see. We always ask for snow removal logs, okay, like if it's in a snow or ice case. We ask for so many things that, the normal person wouldn't think about asking, like a snow plan. And we ask for all of that stuff, and then we get it all, and we take a look at it, and then we get ready for depositions. Depositions, those are the defense's chance to ask you questions under oath, okay? They get one chance to ask you, sometimes more than once, but rarely, one chance to ask you questions under oath about what happened, what you're claiming, what's your injuries, and really detail and preview and get a good look of you at trial. It's not our chance to prove our case. It's not like we're in court at that point. We're in a private office. It's not quite like Suits, if you've ever seen the show Suits, where there's a camera set up and somebody's standing there talking to the camera and the deposition's over after 5 minutes of questioning. No, it's usually 2-3 hours of questioning, and during that 2-3 hours of questioning, what happens quite a bit is they're going to ask a lot of background questions. They're going to ask a lot of questions about anything that in the past, about any past injuries that you've had related to the incident, and then of course talk about treatment and talk about how it's affected your life, these particular injuries. Super, super important part of the case. It's why I do a 2-day deposition prep with my clients 90% of the time. I sit with them. I go over several things the first day with the design of making sure that they understand the process, and then the second day is big time practice, making sure they understand, because practice makes perfect. So those two things, we do them together. The depositions, the 2-day prep, that gets you ready for depositions. Then, once you're done with your deposition, we get to do the deposition of the defendants. The defense attorney represents them. So let's say the business owner, or let's say the snowplow contract or person, maintenance employee that was responsible for shoveling in front of a business. But we're responsible for asking them questions and just kind of proving that they're responsible for maintaining that area. Super, super tricky. A lot of attorneys don't know how to approach those correctly. I always explain it to younger attorneys as we live in a society with rules. First, we need to establish what the rules are and then show what those rules were broken or how those rules were broken. I know one of the things that is always really, really pivotal on a slip and fall on ice case is snow plans, right? Like let's say Walmart parking lot. This happens quite a bit. Sometimes Walmart really has their stuff together, sometimes they don't. And a lot of times Walmart will have their stuff together on one part of the sidewalk, and then let's say they've contracted to like a third-party contractor, like a snowplow company, and that snowplow company hasn't come in 2 weeks and somebody's walking and they fall on ice in that spot. Well, guess what? In that situation, we need to have the snow logs. We need to ask for the logs for when they did work. We need to see receipts of any work that they did, that snow log company. And then we get at depositions, I get to ask those people about that. And that's really good. That's really important to proving liability on the case. The question that I want to talk about as far as the steps, the final step then I should say, is jury trials or getting the case done. At any point the defense can settle. If they can settle 3 months into the case, they could settle 3 years into the case. They could settle right before a jury comes back. They could settle during jury selection. They could settle right during closing arguments, opening arguments. At any point the case can settle. And the final step, like I said, is a trial. And it happens very rarely, but when they do go to trial, you really need an attorney that knows what they're doing in that situation. That kind is the overview of the lawsuit, the steps one by one. We've got complaint, we've got paper discovery, we've got depositions, then we've got trial. And there is some small things that can occur there, like a medical exam in the middle of that, things like that, before the trial. But I'll save you those because those are a little bit long to talk about. And again, those are things that are really important that you have an attorney to guide you through that process. I think going through it alone is a really, really, really risky way of doing things. Quite honestly, you're setting yourself up for a situation where the insurance company knows that they have a better chance to take advantage of you. The next question is, how much do lawyers cost for a slip and fall case in New York State? Well, I can only talk about what I do, and I know that what I do and what my firm does is what the majority of firms do in the area, and that is we work on what's called a contingency fee basis. What is a contingency fee? Contingency fee means that we only get a recovery for the work that we've put in if we get a recovery on your case. So what does that mean? Well, let's say we get a settlement for $100,000. Okay, and let's say that's all the insurance company had was $100,000. Let's say it cost us $1,000 to get the case done. Let's say we spent it on medical records and investigators and things like that. Well, in that situation, we get a third of that recovery, and in that situation, then we'd get reimbursed for the expenses that we paid out, so the $1,000. So the client would walk away with tax-free money. That's a really nice thing. I always say I'm like the tax man, that I helped get you your recovery, and they wouldn't have paid you that. I'm very confident that they wouldn't have paid you that. I always tell people, unless it's a very, 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 very rare situation. So the answer about how much an attorney is it depends. Let's say I worked on it for 3 years and I can count on one hand the number of times this has happened, and we don't get a recovery. Guess what? You don't owe a dime back to our office. That's really nice for your peace of mind. I was always told that the gates of justice, there's 2 ways to get it. You've got the multi-billion-dollar insurance companies who can pay hourly a ridiculous rate to these attorneys. On the other side, who a lot of times we're better than, they're not up to our caliber, but you get a high caliber attorney with our office, and you don't have to pay a nickel up front. The only way that we're willing to take on the case is if we know that we've got a good chance of winning it, and we really, really are very good at what we do. So that's why we can know early on if this is a case that we think we can win, and we'll get it signed up. And really the best way to find out is just giving us a call. Call me right now, 716-848-8000. You can ask for David Wolff. You'll be connected right to me very quickly. You can talk to me about your case, give me the facts, how many years ago, even if it was 2 years ago, you might have still a case. 3 years ago, you might still have a case. 5 years ago, there's sometimes small situations where you sometimes still have a case. You can talk about your injuries, what happened. It's risk-free. It's a free consultation to speak with me. So, how much does it cost to get an attorney for a New York State slip and fall case? It is free to speak with us initially. It is very, very low risk. There's no risk of having to pay anything back to us, which is a really, really, really important thing to make sure that you guys can get the representation you deserve and that you need. I mean, the problem is people go it alone, or they pick the wrong firm that doesn't have the trial history, that doesn't have the good communication, things like that. At the end of the day, you need to feel comfortable. You need to know that you have your own ways to fight back. My clients tell me all the time, I'm just so happy to have somebody that I know is fighting for me. That's what you get when you get an attorney from my firm. The next question that I was submitted was, are slip and fall cases only valid against businesses? What happens if a slip and fall case happens at a private residence? Well, a lot of times, as long as there's insurance, then you can recover for that situation. Homeowner's insurance is supposed to protect the homeowner. And how they do that is if a homeowner has a dangerous or defective condition that causes somebody to fall, that injures them, your homeowner's insurance is there to protect you. And that's why if you feel bad, if you're sitting there right now and you're like, oh my gosh, I feel bad about bringing this lawsuit against this person, they're my next door neighbor. It is against their insurance. This is what they've been paying all those years for. This exact situation. I always tell people, you're in control. I'm never going to go after them personally if you don't want that done. It happens very, very rarely anyways. For me, I think it's really, really important that you understand that just because it's not a business doesn't mean you can't recover. In those situations, you can still recover for the case. Next question, can you file a claim if you didn't immediately report the slip and fall in New York State? So let's say you fell at a business and you didn't go over and report it right away to them. You went home and then you went to the doctors. The answer is absolutely you can still bring a case in that situation. They are fact dependent. It really, really is important to have an attorney in that situation because the insurance company almost always denies unless they have an attorney on the other side that's going to fight for you. And really, it's important to notify the business right away, but speak with an attorney first. The attorney is going to be able to give you a good advice on how to approach that. Sometimes, most of the time, I'll send a letter on behalf of the client, so then they don't have to worry about it. It notifies them in that situation, the business, of what happened, and gets the insurance certainly in a good place right away. Will insurance cover all your expenses from a slip and fall accident in New York State? Insurance, on the other side, will not cover all your expenses unless they feel they are going to lose the case. Okay? And then that's why it's really important to have an attorney. Your health insurance should, depending on the policy that you have, should be willing to help you in that situation and should be willing to take over and pay the health insurance bills. It's not like a New York State motor vehicle case where you have no fault insurance and no fault insurance pays for your health bills. It is Medicaid will pay for it. Medicare will pay for it. Your own private health insurance should pay for it. Again, every case is different, but most of the time the general rule is that the other person's insurance will not pay for it. Your own health insurance will pay your medical bills. And the other insurance company, we go after for your pain and suffering and anything that is not covered through your own insurance. So things like medical bills, out-of-pocket costs, things like lost wages, those are the really, really important things to get as far as from insurance in that situation. Next question that I always am asked, and this happens quite a bit, is it possible to sue a government entity in New York State for a slip and fall case? The answer in that situation is absolutely yes, but there are time deadlines that are as short as 90 days, so get your butt in gear and call an attorney immediately, especially if it's a municipal case. So, for example, I've had cases against the United States Postal Service. I've had cases against the city for premises liability cases, things that they've done wrong in the roadway where they've created a hazard in some way from construction, or all of those types of cases. Those are really important that get notified right away because there's a requirement called a notice of claim to do within 90 days. Just because you don't get it done within 90 days doesn't mean that we can't still fix the problem if you come to us 6 months or 9 months after. But it is important to call immediately. There's no guarantees that we can fix the problem if we're outside of 90 days. The other thing is, it's really important to know with the municipalities and the government entities is that their statute of limitations in New York State is typically a year and 90 days. It's not the normal 3-year window. So if it's a year and 90 days in that situation, that means we've got to get going quickly on these particular cases. So yes, it is possible to sue a government entity in New York State. You really need to have an attorney to know all the ins and outs in regards to that, and it's really important you call immediately. You can call me, 716-848-8000. Call me right now. You can see me on the website, buffalolaw.com. But really, just call me. I mean, we're here to help you. I'll have a quick, honest conversation, and it won't be any problem for you to get an opinion as far as that goes. How injured do you need to be to have a case in New York State? Common question I get asked is, well, I hurt my leg. Do I have a case? Well, depends. Let's say you fell on water, fell on a concrete that was raised, fell on something that was in a premises that was dangerous or defective, like we talked about earlier. And let's say in that situation, you don't know how injured you are. Well, I always recommend contacting an attorney at that point, because the attorney should be encouraging you to go get treatment. Okay, that's number one. So, if you called me right now, I'd say go get treatment. All right, number one. And we don't know how injured you are. Okay, if you just fell and you hurt your wrist, you might have a broken wrist. If you just fell and you landed on your shoulder, you might have tore your rotator cuff or damaged your biceps tendon or any of those things. We won't know for sure unless you continue to get medical treatment. And getting treatment is really, really, really key, improving the injuries on your case. Let's say you fall, hurt your wrist, you don't call me right away, a couple days goes by, you're feeling better. In that situation, yeah, that's probably not a situation where you need to bring a case if you're having a day or two of uncomfortableness, a little bit of pain. But if you're like, hey, it's been a couple days and you're really hurting and your wrist is bothering you, well, guess what? Call me and I'll be like, hey, go to the doctors. Go get checked out. Let's see how you're doing in a few weeks. We don't know how your injuries are going to be. And that's what bothers me so much with people, is sometimes they play the hero when in reality, like, we're all human beings and we all need to understand that our bodies react differently, and sometimes these injuries can linger for a long time. So getting treatment right away, understanding that the treatment that you get, trying to get better, all right? And as long as you're doing those two things and you're still hurting or you're still having problems, it's always worth it to get an attorney's opinion on whether or not you have a case. I mean, what do you have to lose? It's a free consultation. Like, it's a 5-minute phone call and you'll have some peace of mind to know whether or not you have a case. So I always say, just call me, let me talk it through with you, and we'll figure out at that point if you have a real case or not. If you fall and you suffer a fracture rib, okay, and you're 2-3 weeks later it heals and you're feeling better, guess what? I still think that's a case you probably want to call about. You should call immediately once it happens. Call sooner the better on calling. And the reason for that, very simply, is because the sooner that you call, the sooner we can get you to the right people that can help get you better and get you in a place. And remember, the insurance company's sitting there, they're probably already doing work on the case. They're probably already working on trying to figure out how they can defeat you. So, the only way this system works is if, in my opinion, is if you have somebody that knows what they're doing, that's ready to fight back, to know every single step of what the insurance company is going to do, start to finish. That's how you win these cases, is preparing, knowing what their toolbox is of weapons that they use against us, and just getting ready to throw that toolbox right outside so you don't have to worry about it. That's what I would say in regards to whether or not you have an injury. I mean, just call, find out, go get treatment. You got nothing to lose, so there's really no sense in not giving a call. The attorney should be able to tell you what's best for you and what's a good use of your time and what's not. But I always say treatment is really important in getting the person the help they need, of course. So what are some interesting slip and fall cases that I've won in New York State? So I've had some really, really big awards and some really, really successful awards in New York State. One of the top ones that I think of right away was a situation where it was a gas station, a popular gas station chain in our state. And a client came out, opened the door of his car when he was going to pump gas, stepped out, slipped and fell on ice. Well, in that situation, he suffered a traumatic brain injury, very, very, very severe injury. Insurance company the whole time said it was complete BS, that he wasn't really hurt, that he was making it up and faking it. They said they weren't at fault at all. We were able to go to a special sort of trial, and in that trial, an arbitration trial, we won a very significant 7-figure award. We won. And the reason we were able to do that is we were able to show, we had the doctors present evidence in the situation, we had the person testify about the lifelong injuries that they'll have, and we also were able to get the weather expert who was able to come in and show that it was clear out and that it had snowed or hadn't snowed that day, it was the day before that the ice was from. Like, all of those things, that's a case that immediately comes to mind because they were not willing to offer much money at all. And this was a 38-year-old guy who really, for the rest of his life, was going to have problems, and our award made a huge difference in his life. So that's the first case that really comes to mind where I'm like, oh, here's an interesting case. That's an everyday thing that we all do where the business didn't take responsibility, keep it safe. And in that situation, they were held responsible despite not wanting to be held responsible in any way. They had to pay. That's just a perfect example of a slip and fall case, ice case, raised concrete cases. I've had so many of those where we've gotten great results. The key is, like, in these cases, if I were to tell you, what should I do if I have a slip and fall case in New York State? The first thing I'd say is contact an attorney. An attorney is going to be able to guide you. Like, when I get that call, I'm immediately thinking to myself, okay, here's what we need to do right away. Here's the to-do list we need to do, and here's what you need to do right away. And that's really important. Sometimes attorneys are only thinking about themselves, like, oh, I got to do this, this, and this. Really, like, you as a member of the public, you don't know. You're not in the courtroom constantly like we are. So, like, I know what the tricks that they're going to play are, and I know where we can keep them away from having certain arguments if we can do certain things early on in the case. So what you should do is, number one, always contact an attorney right away. It's the most important thing that you can do. Contact an attorney. 716-848-8000 is our office number. You're going to hit 1, you'll get a new case hotline. It'll go to one of the attorneys immediately. Will speak with you. You can ask specifically for me, David Wolff. I will speak with you about everything. I almost guarantee I've had a case like yours before. I mean, there's so many. I've been doing this for over 10 years, or right around 10 years now. And for me, in the experience that I've had in winning these cases, there's things that I can take from every case that I've done in the past that can lead to success in your case. And that's why it's so important to have legal representation, because when you do it, you go on your own. It's never a good thing to show the insurance company that you think you can handle it alone, because the reality is that they are only afraid of one thing, like I talked about earlier, and that's verdicts. So, slip and fall cases in New York State, we've got to prove dangerous and defective condition. We've got to prove that it caused an injury. And we've got to prove that they knew or should have known of the dangerous or defective condition. These things are not easy to do, but they are very winnable cases. They are winnable cases because in New York State, the law is designed to help somebody that's injured. It is designed to be your friend. It is designed to be our ally. It's designed to protect you in that situation. So, from my standpoint, when we talk about what the injuries, whether or not you have a slip and fall case in New York State, there's just so many factors and so many different ways that we can attack, that we can bring the case, that we can fight for the client. We make sure every case is different, like every person is different. And from my standpoint, if you don't prepare, like we have to go all the way, like I'm going to have to take this case to trial out, like even though 99% of them settle because of our track record, if I still prepare every case like it could go to trial. And that's kind of the difference, I think, that really sets us apart in some ways in the communication that we have with clients. And there's certainly other good attorneys out there, but I always say that we make it easy for you. We designed our system to make sure that the client knows every step of the way of what we're doing. Outfit change. Okay, let's wrap up and kind of conclude and talk about what are some of the most important things to go over in regards to a slip and fall case in New York State. So there's many different paths to success, and each case has a different path to success. Some cases, trial can be the best option. Some cases need to be settled relatively quickly to get the best result for the client. It's really a situation where the client is in control, and the person that has slipped and fell is in the control of which direction they want to take the case. So when we talk about the big picture of what we're trying to accomplish, again, hiring an attorney is really important because they know the different ins and outs of everything. But there's just so many paths, and the ultimate goal is always one thing: justice and compensation for that person who is injured as a result of the slip and fall. Someone else had a dangerous or defective condition, and that dangerous or defective condition caused an injury. So, as we kind of wrap up here and go through the different ways we can get a recovery, remember there's a settlement, okay, which is always our best bet. If we can get a settlement, it means less litigation costs, less expenses, and less time for the client. And again, when you hire an attorney like myself, like my firm, and me, if I were to take on your case, what I do is I front all the case costs, and then what happens is that at the end of the case, the client reimburses me only if we have a successful result, meaning that we've gotten a recovery for them. So one of the things that people get really nervous about is, hey, what if I sign up? What if I don't have any sort of success in the case? Well, that rarely happens, but when it does happen, you're protected. The person is protected in that situation in writing, in the retainer agreement. And in that situation, the person can know, hey, listen, I'm never going to owe a dime here if I can't get a recovery or if something goes wrong in my case for whatever reason. And that happens very rarely. I can count on one hand the number of times that's kind of occurred in my cases over a 10-plus year career. But in that situation, it is rare, but it can happen, and you'll know that you are totally protected. But we talked about settlement, we talked about verdict, arbitration award. Those things are different paths, and those things are different ways that a client can be successfully compensated for an injury claim. Those are ways where we can get things done quickly, where we can get things done without the hassle of a courtroom at times. That's really important. Ultimately, again, all of those different avenues are ways for the client to be successful. It's just each one of those ways has different difficulties with getting there. Not all insurance companies want to go to arbitration. Not all insurance companies want to settle cases out of court, without an attorney especially. Not all insurance companies want to pay fair value immediately on a claim. I mean, there's a reason that I have a job. It's because people get taken advantage of by insurance companies every single day. And that is what really drives me crazy, is when I hear these horror stories where a client calls me and says, hey, I took a settlement on a slip and fall case for pennies on the dollar. They'll tell me an amount and say, hey, was this fair? And I have to be honest with them. You know, they're asking for my opinion. I'll say, well, look, I think I could have done better, or I could have gotten this result. I'm pretty confident. Again, there's always no guarantees, but there's a reason that I am so successful and that my firm is so successful. That's because we know how to win them, how to get to the different points, and how to be successful in driving the settlement value. All right, so I want to just leave you with one more example of how we can win a personal injury case, or how we can add value to a slip and fall personal injury case. Just got a call the other day. Individual called me. They said, hey, I was hurt. I was walking down the street. I tripped on a curb that was hidden. My immediate antenna went up. How can we help this person? There's special laws that protect municipalities, which means like government entities. There's special laws that are time deadlines for those that need to be done right away. Perfect example of met with the individual. They had been offered $1,500. I was able to figure out where that insurance company was basing that decision on right away. And it wasn't the municipality that owned the roadway. No, it was a construction company that had done work on the curb, that hadn't done a proper job. It was in a very, very bad condition, and it led to the individual falling. As a result, they were already offering her $1,500. Her injuries were worth well over $20,000 to $30,000, and that was early on in the case. Her injuries could develop into significantly more. So she called and asked, should I take it? My immediate answer was no. No, do not take that. Here's how we can add value to this claim. And I will tell you that already, we've already put the insurance company on notice that we're involved, and their tone has completely changed from when she was talking to them versus when we were talking to them. What does that really mean at the end of the day? It just means every case is different. And there are important evidence, and there are important things that need to be done right away. And there's also important things that need to be done 6 months from now, but the initial steps need to be done right now. Always, always, always treat. We can help make your life easier, where all you have to worry about is the treatment side of things and getting better. Something that really gives my clients peace of mind as far as that goes. But all of these things, they are very difficult if you're navigating things alone. And that's what the insurance company wants. They want you to navigate things alone. That is just not the way that things are supposed to go when you are injured as a result of somebody else's negligence. It's not just me at my firm too. One of the things that we do is we really collaborate on cases. I want to talk specifically about the partners at the firm. I've been doing this for about 10 years now. I've seen just about any type of case, but every day something new walks in the door, and it's a new story, it's a new injured victim, and it's somebody who we need to figure out a new plan for, and the plans are different for everybody. It's not a cookie-cutter formula. Joe Nicastro, my partner, a guy who was a former rock star, toured all over the country, went over to Europe for a little bit, got to play with Paul McCartney at one point. He's got an incredible backstory. He's been a personal injury attorney for about 10 years now as well. He's got a ton of success, ton of experience in slip and fall cases and knowing where to navigate these cases and where not to. And then our final individual, the final partner is Rich Hall. He's like a bulldog on cases. He's a guy that doesn't get pushed around easy. And it's great because we all work as a team. We've got tons of attorneys at the office. And like I said, always, I'm very easy to work with. Rich is easy to work with. Joe's easy to work with. Our team is easy to work with. We make things easy for you. And Rich is great at being a bully to the insurance company and making sure certain things aren't done. And then I come in and can play the good cop at times and make sure that we can get a deal done. Everybody has a different role in negotiations. And that's another great thing about a firm, is that you get the best of all those worlds. We're not a mill, we're not somebody who's just churning out cases to try and get things done. Slip and fall cases, if you negotiate them on your own, you've got to be your own advocate, you've got to be your own expert on the law, and you've got to be your own good cop and bad cop. Not always easy to do. That's why, teamwork is key. Everybody's got a piece of the puzzle that they fit into. So, the whole case, the whole slip and fall case is like a puzzle. And that part of the case might be depositions or treatment or doctor treatment. All these things are pieces of the puzzle. And if you try and fit into something that you're not, the puzzle doesn't fit. And that's always what winning a personal injury case and winning a slip and fall case in New York State is about. It's about fitting all the pieces of the puzzle together so they fit. And it's about figuring out how to make sure the pieces of the puzzle fit. Because here's what the defense wants to do in the insurance company. The insurance company wants to grab those pieces, rip them. They want to make some of the pieces larger. We've got to be working together to make sure that the puzzle pieces are all together. That can be evidence, that can be medical records, that can be just simple communication between the attorney and the client. All of those things have to fit together for the puzzle and the case to be successful. So I want you to think about giving us a call and then just say, you know what, I'm not going to think anymore. I'm just going to call. Cantor, Wolff, Nicastro Hall, 716-848-8000. We win. It's just that simple.